I'm going to open us up.
Okay.
Welcome in, everyone. Welcome to Care Concierge with CarePatrol, where education is the heart of everything we do. If you're new to Zoom and new to Care Concierge and CarePatrol, we are an aging care navigation company, which means that we help clients and families who are in the midst of either a crisis or a planning stage understand what aging care options are available in the market. If those include community placement, we tour clients, much like a realtor might. And like a realtor, we're at no charge to those clients we tour. We're paid by the providers if and only if one of our referrals ends up moving and locating themselves into that new community. So that's how we work. And we do focus on education and hand-holding and advocacy with our clients. And as an example of that, we try and focus on education with you, the social workers and nurses across our state and even beyond our state. We appreciate you being here. We do these CEU courses most every Monday of the month. Today, we have a returning guest presenter, Bill Nolan of the Alabama Elder Care Law Firm, who's done many topics with us, and we appreciate his time. In order to receive credit for us, and we are accredited by the Alabama Board of Social Work, and we're also accredited by the Alabama Board of Nursing. And in order to receive credit for today's course, you must complete the evaluation, which is online at the conclusion of this event. And make note that this is password protected. So we give out the password for the evaluation at the end of the hour. And this way, we ensure that you stay for the whole hour. And the Alabama Board of Social Work agrees that through this process, this is considered a live or a classroom hour for you. Nurses who complete the evaluation, we will actually enter your hour for you on the Alabama Board of Nursing website. Social workers and nurses, everyone will receive a certificate who completes the evaluation, which closes tonight at 8 o'clock. So you will not see a certificate from us until later this evening or sometime tomorrow morning. But if you do the evaluation, of course, you will receive credit. Those of you who've been with us know that I like to read to you the evaluation link. That way you have it. I've also posted it into the chat room for you. The link, if you're ready to make note of it, if you're not looking at a screen but have a pen in hand, the link is https://www.surveymonkey.com/r/ all uppercase letters with some numbers, C as in cat, 3, L, C as in cat, 7, G as in girl, Z as in zoo. That is our evaluation link for today. I know that our speaker, Bill Nolan, and I both appreciate discussion, and you're welcome to interact with us through the chat room. If you're new to Zoom and you're not familiar with the chat room, move your cursor to the top of your screen. A black bar should pop down. If not, move it to the bottom. A black bar should pop up. On that bar is the word chat. Please join us in the discussion. We'd love to hear your observations and your outcomes, as they only enhance what we say to you as presenters. So without further ado, now I'm going to pass things over to our speaker today, Bill Nolan. And Bill, thank you again, as always, for joining us.
My pleasure. It's always a lot of fun to have an opportunity to present to your group of folks. They ask great questions, and it's nice to have an audience, a friendly audience to speak to. So today we're going to talk about another area of the law that we deal with. We've talked about Medicaid in the past. We've talked about estate planning in the past. I think we talked about probate in the past. Today we're going to talk about guardianships and conservatorships. It's a topic that unfortunately comes up all too often. In fact, it's coming up more and more often for us, and who knows why. I mean, I know dementia is certainly one of those areas that creates the need for guardianships and conservatorships, but it also seems like there's I don't know, an increase in mental illness in seniors, possibly because people are living longer, or it may be because of drug interactions, or maybe because physically people are a little healthier than they were 20, 30 years ago, but mentally they're suffering. Who knows? But we thought it would be a great topic, not just professionally, but also personally, because you guys and your families, you're the experts when any of these topics come up. And people are going to ask you questions. And wouldn't it be nice to have answers for them so that you can help? So that's what we're going to talk about today: personal, professional, or somewhere in between. Guardianships and conservatorships. And certainly you're welcome to post any questions you might have, and we'll try to answer all those before we're done this hour. Everybody on this call, I'll bet, has seen situations like this come up. We see them, you see them. Unfortunately, they come up in our families. Elder financial abuse is rampant. And the odd thing is, your mom or your dad, your uncle, your aunt, grandmom, granddad, they're victims, and they don't seem to know it. They seem to think that the Publishers Clearinghouse is going to send them a check any day, or that man that they've never met who has been calling them is coming down to sweep her off her feet any second now. Or dad falls in love with this 50-year-old caregiver who he is convinced deeply loves him, even though he's 85 years old, and she's going to marry him and take care of him the rest of his life. And everybody else can see through all that. So there are all sorts of situations that come up. And the sad thing is, the victim, the person who's the center of all this, is the last person to realize there's a problem. Situations like that, if they rise to a certain level of seriousness, might require a third party to get involved. And luckily here in Alabama and most states, there are procedures in place, there are laws in place to take care of situations like that. Here in Alabama, we have two different roles. One's called a guardian, the other's called a conservator. Some states lump them together into one, but here in Alabama, we still separate them, chiefly by the job description that each one has. A guardian is a person the court appoints to look out after another person whenever that person, has been determined by the court to lack capacity. And a guardian makes personal decisions for that person, where they live, what hours they keep, who gets to visit them, who can't visit them is really important. Maybe what clothes they wear, what they do for fun, that kind of thing. It's almost like you have a rebellious teenager and you're trying your best to take care of them regardless of their intentions otherwise. A conservator, on the other hand, in some ways has a simpler job. Their job is to manage the income and the assets of the incapacitated person. So in many cases, your mom or your dad or whoever it is has an IRA or some savings, investments, bank accounts, and they have their Social Security and maybe teacher's retirement coming in. And somebody has to manage that. And so a conservator is appointed to account for all of that money and to distribute it to either the guardian or to the person themselves as needed to pay for their living expenses, medical expenses, and that kind of thing. A guardian typically has to live close by the incapacitated person, unless the incapacitated person is in a home, either independent living, assisted living, memory care, or skilled care. The guardian, if the guardian is taking care of the person in the community, the guardian really needs to be close by. Otherwise, you can't really look out after a person very well. A conservator, on the other hand, could be on the other side of the world as long as they're managing their money electronically, one way or the other. Some of you might say, well, that sounds like what a person could do under a power of attorney. And you're right. if you have a good power of attorney, it will accomplish 95% of what you could accomplish as a guardian or a conservator. The difference is a power of attorney can be revoked by the principal. So if your dad has a power of attorney and you've been appointed the agent, you can make all those financial decisions. You can make decisions about where he might live or what assets to be sold, need to be sold, and that kind of thing. The difference is if your dad doesn't like it, he can revoke that power of attorney and you don't have any authority anymore. A guardianship and conservatorship, on the other hand, is not revocable. It's not a voluntary situation. If your dad had a guardianship and conservatorship over him, the courts made you guardian and conservator over your dad, it doesn't matter what he does. He can't revoke it. It can only be revoked in the court, and it is a tall order indeed to have a guardianship conservatorship revoked by the judge. So yes, a power of attorney can work 95% of the time, assuming the person you're trying to help goes along with it. The thing is, even if you have a power of attorney in place, if your mom continues to give money away or continues to hoard, or your dad continues to drive, even though the doctors have said he shouldn't be driving, there's not much you can do as agent because you work for the principal. Whereas with the guardianship and conservatorship, you've been put over them. You don't work for them. You work for the court. You're just looking out after them. So we've talked about these incapacitated people. What is an incapacitated? Who is an incapacitated person? You know, we call it the party in need of protection in the petitions that we file, but the person has to be incapacitated in some way. The way we see it most often is a person who is incapacitated due to advanced age, you know, dementia of some sort, Parkinson's, or mental illness that's come back after so many years of being taken care of, medicated. Although, you know, an incapacitated person could be incapacitated technically because of their age. You know, they could be a minor, or they could be a drug addict. So we see it most often because of advanced age. And I would guess that with seniors, that's always going to be the case. We don't handle any minor type guardianships. There are other law firms that do. And obviously they would see it because of age, not infirmities. Who can be guardian? I think that's a great question because that's oftentimes a point of discussion. You know, 4 or 5 kids come in to meet and say, "Mom or Dad's doing this or that," and we say, "Well, who wants to be guardian?" Well, can we all be guardian? No. You can't all be guardian. You have to have one person as guardian. You know, somebody has to be in charge, the point person. So they have to decide, well, who's the best person to be guardian? Well, the law says that the priorities are established this way. The first priority, the highest priority, is if you have stated in your power of attorney that if you needed a guardian or conservator, well, you want the persons that you've appointed as your agent in that power of attorney to be your guardian. Well, that's great. You know, in our powers of attorney, we draft it that way. So it says in your power of attorney, it says, I don't want a guardianship or conservatorship, but if a court ever determined one was necessary, I want my agent that I've named herein to be that person. Well, that's strong. That puts you at number one, and it would even put you above the person's spouse. If you don't have a power of attorney, though, or your power of attorney is defective and it doesn't include that provision, well, then your spouse would be the next one. But the fact is, you know, by the time you get to be the age where one of these might be necessary, your spouse might not be much better off than you are, you know, because of advanced age. So sometimes that's not the best way to go. So the next one would be a child, an adult child. And that's the one we see by far the most. Well, I've never done one in years of doing this where a parent has been named over a person because, you know, you're 80, your parents are 100, they're not going to be able to do that if they're alive at all. although you could have uncles, aunts, brothers, sisters, people like that could be appointed as well. And then lastly, if you have a caregiver, a friend who's taking care of you, they could be appointed guardian as well. The rules are pretty lax to be a guardian. I mean, you don't have to be bonded, you don't have to be insured. I think that if you had a former felony conviction, you might not be able to be guardian, but something less than that, you could probably be guardian. Bankruptcy, you could be guardian. What does a guardian do? Well, like I said, a guardian is the person charged with taking care of the party in need of protection, the incapacitated person. So their job is sort of like being a parent. This is from the code right here. And it's worded this way because in some counties, the sheriff in the county will be appointed guardian and conservator over what's called the ward. Yeah, that's a scary thought when you think about it. But it's a way for the county to make some money, the way for the sheriff to make a little bit of extra cash on the side, unfortunately. So the sheriff, if he were appointed guardian of a person, well, he would have to go out there and get to know him or get to know her. Mrs. Smith, I'm the sheriff, tell me a little bit about your life history, your kids, your family, how, that kind of thing. The reality, though, in most cases, when the adult child is appointed guardian, I mean, they know mom and dad's story. They know the relatives. They know the whole thing. So the adult child would make sure that they become involved in their mom or dad's life, but maybe more thoroughly than they have been. Well, who's their doctor? What hospital do they go to? What pharmacy do they use? What prescriptions are they taking? When's their next appointment? Who do they go to take care of their dog or their cat? Who's their veterinarian? That kind of stuff. Just those little details of trying to be involved in another person's life like that. To help the person be as independent as possible, that's a big deal. If they can't be independent, well, to help them find a place to live. You might call Sean, for example, and say, Sean, I don't know what to do. I'm guardian, but they can't live alone anymore. Can you help me find a place that would be suitable for them? And sometimes, unfortunately, that means a place with security, a lockdown facility. The guardian would possibly be in touch with the conservator from time to time and say, it's it's in the month and we need to pay XYZ. His income, as is not sufficient to cover that. Or maybe he needed this medical procedure or this copay and we need to pay these bills. So the guardian would pass those bills back to the conservator to be paid. So it's pretty comprehensive, especially if your party needed protection is still in the community at large and not living in a more controlled environment. Well, what about a conservator? Well, who can be a conservator? Well, again, you can appoint somebody to be your conservator in your power of attorney, if you have a power of attorney. Ours does that very thing, although I can say that not every power of attorney does. If in the rare event you already have a conservatorship over a person from another jurisdiction, let's say, for example, your mom has been living down in Florida for decades, and there's an existing conservatorship over her in Florida, but now she's moved to Alabama to live with a child here. Well, the person who was appointed conservator in Florida can ask the court to have that transferred to Alabama, and they would stay conservator here. Rarely comes up, to be honest with you, but it could. A person could select their own choice of conservator. Let's say, for example, you have a parent who is pretty independent, maybe still working part-time, but she has lost the ability to manage her financial affairs. She's still able to cook and clean and get dressed and remember to take her medication and that kind of thing, but she just is worthless at managing money. Or maybe she was never good in the first place with managing money, and now she's really bad at it. Well, you could have a conservator appointed over her and not have to do a guardianship at all. So that person could say, Judge, I want my daughter who's taking care of me to be my conservator. A spouse can do it, although rarely does it come up, with a spouse. Often it's the adult child who steps in to manage a person's finances, never a parent for that matter. So it's wide open, but this is the priorities that the state law has basically chosen. Some of the duties, obviously, in terms of managing money, would be investing their savings, their IRA, 401k, retirement assets, managing their income as it comes in, their Social Security, teachers' retirement, railroad retirement, whatever it might be, to make sure that the money lasts. We calculate for our clients what we call a burn rate. And a burn rate is we take their income every month and then we compare that to what their living expenses might be every month. And if a person's in the community, let's say they're still living at home, their house is paid for, well, sometimes their monthly income is more than enough to cover all those expenses. But let's say they move to independent living. Well, that could be $3,000 a month right there. Their income might no longer be adequate. So we have to look at their assets and how much is necessary monthly to cover their expenses. And let's say they move into assisted living. Well, now it's $4,000, $5,000 a month. How much is going to be necessary from their assets? So we can calculate out into the future at what point in the future they're going to be totally out of money, for example, just as a helpful resource to the conservator. A conservator can buy property, can sell property, although not real estate. Let's say that your dad has a conservatorship over him and he had a lake house. Let's say he had a lot that someone else owned, but he rented it and he had a mobile home on that lot and he had a boat. Well, the conservator could sell the boat, could sell the mobile home because a mobile home is not real estate, and invest the money back into some savings account so it can be managed more closely by the conservator. One of the things that comes up, though, that a conservator can't do, a conservator can't sell real estate unless the court approves it. And that's a problem because a lot of conservators, they figure it's an asset. I'm in charge of the asset. I'll sell the house. And that's a big no-no. So we make a point of having that conversation with conservators. You can't sell their house without getting the court involved. The court has to approve it. And then you can sell it. But don't even try to sell this house unless the court's approved it, because you'll be in big trouble with the judge otherwise. So just remember that a conservator can't sell the house. They can sell personal property, but not real estate. So how does all this begin? We've defined a guardian, we've defined a conservator, we've defined an incapacitated person, but how does it really take shape in real life? Well, the first thing we do is we meet with the client. The client's usually the person who wants to be guardian or conservator, or they might just be the adult children and they're up to their eyes in problems. They don't even know what to do. And that's where we begin the conversation about guardianships and conservatorships. So the first official thing is we prepare the petition, and that petition will be filed with the probate court. And that petition, it alleges certain things. It alleges it states, Mrs. Smith is a 78-year-old woman who's been a resident of Jefferson County for more than the last 6 months, for example, and suffers from a number of medical conditions, each one causing a problem with her ability to manage her personal affairs and her financial affairs. And we'll have some sort of a document from her doctor, and that will say, I'm Dr. Jones, and Mrs. Smith is my patient, and she suffers from a medical condition that's going to require her to need the help of somebody else to manage her affairs. That's all it has to say. That's the examination, the initial document. Now the court, when we get all this rolling, the court will ask that doctor to re-examine her to make sure that condition is ongoing. When we file the petition, though, the court will appoint two different individuals. One's called a guardian ad litem, and one's called a court representative. And I'll bet some of you in this call have been a court rep or a guardian ad litem before. A guardian ad litem's job is to simply make sure that the person's condition requires this level of involvement. That is, this is the least restrictive option for that person. They're not trying to adversely affect the outcome of this, or try to overturn it. Their job is merely to make sure that the person needs it. So they'll go out and meet with the person. And most guardian ad litems have done this a time or two before, and they know that the person who is the subject of all this probably doesn't want it. So they can see through that kind of thing pretty easily. They're also looking out for kids adult kids who might be using this as a means to take over mom's money for their own benefit. So they're going to be looking out for that kind of thing. They want to make sure the person's living in environment's clean and safe, and the person who's asking to be appointed is the right person for it. So their job is to, in some ways, represent the party in need of protections needs, but not to necessarily try to terminate this. A court representative is also appointed. They're usually somebody from DHR, at least around here they are. It could be another lawyer, though. It could be a social worker not associated with DHR. Their job is to make sure that the person's medical needs or medical condition rises to the level of this kind of proceeding. And they'll talk to the doctor, they'll look at the chart, and they'll write a report for the court to rely on. So the petitions filed, these appointments of guardian ad litem and court representative take place, and the court sets a hearing date 30 to 45 days in the future. By then, the guardian ad litem's visited with all the parties, the court reps done their job, and they've written their reports, and now we get to have an actual hearing. Now, the state law says a jury can be demanded, but I've done this for I don't know how many years, and I've never once had this go before a jury. So yeah, it's part of the law, but it doesn't happen. Usually it's going to be right there before the judge, and that's it. And we'll have a hearing, and sometimes the party in need of protection's there, sometimes they're not. It could be more confusing for some people than beneficial. So the guardian ad litem is the person who would decide whether it's necessary or not. And the court would say, well, Mr. Nolan, what's this all about? And I'd say, well, Your Honor, we filed a petition to ask the court for a guardianship and conservatorship over Mrs. Smith. She's a 78-year-old woman who lives here in Jefferson County, and her doctor's Dr. Jones, and he says that she needs somebody else to be appointed to make financial and personal decisions over her. Her daughter has asked the court to be appointed in both of those roles. Now, you can be both, or you could be guardian and your brother or sister could be conservator. So many of the times, I'd say half and half. Sometimes it's one person serving in both roles. Sometimes it's one child over a guardian and one child over a conservatorship. The judge would say, well, who are you going to call as your first witness? And I'd say, well, I'd like to call the petitioner herself as the first witness. And just like on television, you take the stand and I ask you some questions. Who are you? What's your relationship to the party in need of protection, Mrs. Jones or Mrs. Smith? And, could you tell the court narrative fashion some of the instances that have caused you to file this petition? Well, mom keeps sending checks to Publishers Clearinghouse, or mom keeps giving her phone number and bank account number to people calling her from out of the country, or dad keeps doing this or that, gambling or sending money away or hoarding, whatever it is. The judge oftentimes asks questions, like, well, tell me a little bit about that, or explain that. Other people can testify. In fact, some people occasionally would argue. They might take the stand and say, this isn't necessary because of X, Y, and Z, although it rarely comes up. You could have children who could argue, Judge, if the guardianship is necessary, I should be the person and not my sister. But again, that rarely comes up as well. Typically, the court would rule from the bench and say, well, Mrs. Smith, I understand that you think that your daughter wants to take all your money and put you away in a nursing home. And that's what everybody thinks, but the reality is your daughter's trying to look out after you and protect you and make sure your money lasts for the rest of your life. So I tell you what I'm going to do. I'm going to appoint her your guardian and conservator, and just understand that she's there to look out after you and your needs. She's not trying to put you in a nursing home. And if you ever have any problems, you can always come back to the court here and we can talk about it. So the judge literally appoints you as her guardian conservator. You get called an order of guardianship and an order of conservatorship, and then you have letters of guardianship and letters of conservatorship awarded to you. You can take those letters of conservatorship to her bank and say, I've been appointed mom's conservator. I need for her bank accounts to be changed over into a new type of bank account that would have you as the person writing the check. So once this is done, your mom, if she's the party in need of protection, she no longer has access to a dime. Her income would be deposited to that new bank account, and her existing savings and investments would be in that new bank account with you as conservator over it. So nobody has access. Even if she were to give, your mom wouldn't even have that bank account number, so she couldn't give that away. You would be effectively cutting off any elder financial abuse that's taking place from this point forward. The conservator has to take an inventory of mom and dad's, or whoever the person, party in need of protection might be. They have to do an initial inventory. And the reason is, sometimes, let's say that your mom is the party in need of protection and she's very paranoid. She doesn't want to tell you anything about her financial situation, where her money is, what banks she uses, what her income is. So when you're asking the court to be her conservator, you might not have a clue about the specifics of her banking and financial arrangements. Once you're appointed, then you can learn all of it. So after 60 or 90 days, 60 days in Shelby County, 90 days in Jefferson County, your job is to report back to the court a snapshot. Basically you're saying, Judge, since I was appointed 60 days ago, I've learned that mom banks at Wells Fargo. And I've learned that her income from teacher's retirement is X. Her income from Social Security is Y. And I've learned that she has a credit card with Discover, and the balance is whatever it is, that she has savings of this, and she has an IRA at the credit union of that. And all of that becomes your starting point as conservator. That's the baseline. That's how much you're starting out. So the conservator has to be bondable. I'm way down here at the bottom of this slide. That's one of the initial elements that we have to establish before you can be awarded or you can be appointed as conservator. A bond is a third party's affirmation that you're good for it, basically. A bond is usually well, you've seen these bail bonds out by the court in jail. It's where a person gets arrested and they can get out on bond, which means that when their hearing comes up in a week or two, a month or two, they're going to show up for that hearing. If they don't show up, then whoever posted this bond loses it. And it could be a mortgage on your house or a bank. Anyway, a performance bond for a conservatorship is similar to that. What you're doing there is the conservator is saying, I'm going to take care of mom's money. And if I fail to do so, if I run off with mom's money to Mexico, this bonding company has already determined I'm good for the bond. And if I do run off, the bonding company is going to pay the court, and then the bonding company is going to come after me, which you don't want that to happen. So it's a performance bond in a way. Since you're managing somebody's money and somebody's income, the court wants to make sure that you're good for it. So this bond is posted and paid for every year while this conservatorship is in place. And What that means, of course, is that not everybody can be a conservator because you have to be bondable. And let's say that you file bankruptcy 10, 12 years ago. Well, you're not bondable. That showed a poor financial skill set, and the bonding company is not going to take that risk. Or let's say that you've been arrested for bouncing checks. Well, I think it's safe to say that you're not going to get a bond for that. So not everybody can be a conservator because they can't be bondable. And that's probably the single largest hurdle for our clients is they have they're local, they know their mom, they know their dad, but they can't get a bond because of poor credit history. So in that case, well, what happens? Well, you can have somebody else be conservator, or you can let the county become conservator. And I'm not a big fan of the county being conservator, but sometimes that's the only thing you can do. Or let's say that in a family situation, 4 or 5 kids, are arguing over who should be conservator and nobody's the clear favorite. Then you could say, Judge, rather than let any of the kids be conservator, let's just go ahead and get the county involved as a neutral party, and they can do that. And, they're going to charge money for it, but it may still be the best thing for your mom or your dad. By the way, as we said, the power of attorney can give you as agent the authority to be appointed guardian or conservator in the future if a person's capacity starts to decline. So while your mom or dad's got full capacity, they say, we're going to sign this power of attorney and we're going to make you, son, our agent. And if down the road we lose our marbles and can't take care of ourselves anymore, well, that's okay. The power of attorney says we want you to be our conservator and guardian if that were to take place. Well, that's fantastic, because not only have you moved to the top of the list in terms of priorities, but you also say in that power of attorney, I'm giving my agent authority to talk to my doctors to obtain my medical records. Well, the problem is, you all know what HIPAA is, the Health Insurance Portability and Accountability Act. What it says is that your medical records are only available to whoever you've given permission to see those records. So if you don't have something in writing to show that you've given permission, well, they don't get to see them. One of these catch-22s that we see come up with families is mom doesn't have a power of attorney. So mom hasn't given anybody HIPAA authority because she doesn't have a power of attorney or healthcare documents in place. So remember we said that one of the required documents to have in order to file a petition is something from her doctor saying she lacks capacity. Well, let's say that the daughter goes to mom's doctor and says, Doc, we need you to write down something that we can give the court that says mom lacks capacity. The doctor quite rightly says, I'm sorry, I can't do that. That's HIPAA protected information. Well, how are you going to get that information if it's HIPAA protected? Well, if you're a guardian or conservator, you can get it, but you can't become guardian or conservator without that information. So it's a problem, as you can see. A proper power of attorney would give you that authority as agent, which you would be able to use down the road to become guardian and conservator. But not every power of attorney does that. And I can tell you, they vary widely. Our power of attorneys do that, but not every lawyers do that. And again, not everybody has a power of attorney in the first place. So be aware of that. A power of attorney does a lot more than just say who can write your checks and make deposits for you. It would take care of you down the road. This can effectively stop a guardianship or conservatorship moving forward. If you can't get that doctor's statement, you can't really move forward to the guardianship and conservatorship, unfortunately. We talked about this initial inventory. Again, it's important because what you're trying to do as a conservator is to show the court, this is what you've made me responsible for. Mom's monthly income, mom's assets, possibly taking care of her house if it doesn't need to be sold. So what you're trying to do is to establish up front, this is what I'm managing for the court. That's your starting point. And that's established within 60 to 90 days of you being appointed. Now, the court also, this is why it's so much harder to be a conservator than a guardian. I mean, yeah, it's the responsibilities of a guardian are more comprehensive than they are as a conservator, day to day, what they eat, where they live, who they talk to, who they can't talk to. But a conservator's job is managing their assets, and they have to be reporting these that work to the court. Some counties have a once every 3 year, they call it a triennial accounting. Shelby County makes you do it every year. And most counties are moving towards an every year kind of accounting, but Jefferson's still on the old system. So what an accounting is the conservator, let's say you're doing it in Jefferson County. The conservator starts with this initial inventory showing their assets and their income. And then 36 months later, the conservator sends in this fairly detailed accounting to the court. And it would say, Judge, 36 months ago, you appointed me conservator. And at that time, the person's monthly income was this much and their assets were this much. Well, every month for the last 36 months, we've paid out X dollars from her income, and if insufficient, from assets. And this is where we are now. Because we had to invade principal or their savings a little bit each month, this is where we are now in terms of their total assets. If you sold the home during that 36-month period, you say, Judge, 24 months ago, we came to this court, asked the court permission to sell the home, which we did. And as we reported to the court then, we were able to get $200,000 from Mom's home sale, which we invested in her investments. And that money is now worth X. And that way the judge can keep up with fairly closely how well you're doing as conservator. The bonding company can make sure their bond is still valid and safe. And anybody interested, let's say the guardian or other family members, can also look and see that the conservator is not mismanaging the funds. So it's a big deal. And it's not easy to do an accounting every 3 years. That's why Shelby County and some of the other counties are going to an annual, because they figure if you make a mistake, well, you can correct it after 12 months, but after 36 months, sometimes the mistake is so ingrained or so deep that you can never recover. So I'm in favor of every year, but it does put more strain on a conservator. Although it also can help them start with a good system and stick with a good system, whereas they might not have a good system after 36 months because nobody's looking over their shoulder until 3 years down the road. So what happens next? Well, the conservator's appointed, the guardian is pretty much free to do whatever the guardian wants to do, making decisions for a person, where they live, what they do, who they visit with, what their hobbies are, that kind of thing. It's very loosely managed. A conservator, though, has to keep up with all these records and be responsible at any time to report to the court or to anybody else that might. Sometimes people will say, I don't trust the conservator, what they're doing. They're mismanaging Mom's assets. One of the other children, maybe one of the children who is fighting with the conservator over things, they can drag them back into court too. So you have to keep good records and be able to account for your actions. At the death of the party in need of protection, a final accounting is due. Even if you just did one 2 months ago, you have to do another accounting at that point. And you would say, Judge, 2 months ago, we submitted our annual accounting. Well, Mom died. And so we're giving the court an accounting from the date of that last accounting, the annual accounting, until her date of death. And then usually that money would once we have that final accounting hearing, the money would be released to her estate, to her executor if she has one, or to the administrator, if there isn't one, to be distributed to next of kin or beneficiaries. So it's a big job being a conservator. It's not an easy job being a conservator, and you want somebody who's really good with numbers to do that. There is something called a limited conservatorship, just so you know what it is. It's when a person needs Medicaid. This is where we see it the most. A person has been in assisted living and maybe memory care, and now they've gone to skilled care, and it's obvious they need to apply for Medicaid to pick up that $8,000, $9,000 a month tab at skilled care. Well, the family, let's say that you don't have a conservatorship. If you did, you wouldn't have to do this, but let's say the family's been operating under a power of attorney up until now. And that power of attorney doesn't give the agent the authority to do Medicaid planning, which might be talking to Medicaid, doing the application. It might be setting up a qualified income trust or an Alabama family trust to take care of assets or income. And their power of attorney doesn't give them that authority. Well, a limited conservatorship is an option where we go to the court and say, Judge, we need to apply for Medicaid ASAP. The party in need of protection has this much money in the bank and this much income, and we can't move forward because their power of attorney is defective. So would the court order this limited conservatorship merely for the purpose of applying for Medicaid? And the court always does. The downside, though, is it's still going to cost $3,500 and take maybe 2 months to get in place. And, you know, every month that you're in skilled care privately, it's going to cost you $8,000, $9,000 a month. So if you could speed that process up a good bit, you could save a lot of money. Well, a good power of attorney costs $350, and it could take care of all this. But a bad power of attorney, a defective one, doesn't. And we see a lot of bad powers of attorney. And what it ends up costing is the $3,500 to do the limited conservatorship, plus maybe $8,000 or 2 months worth, $16,000 of private pay skilled care that you wouldn't have had to pay had you had a good power of attorney. So just remember that when you're talking to people, make sure you have a good power of attorney, because they can end up costing some real money, unfortunately, if you don't. Lastly, there's something called an involuntary commitment, and some of you have probably been involved in that. That's where a person is acting crazy. They're doing something that is a threat to their safety or to someone else's safety. You know, they're, flashing guns around or shooting guns off at night, or they're walking down the street naked, or they're, driving drunk or driving under the influence of something, or just, something that would put someone at a risk of life or limb. You can go down to the courthouse and fill out a petition for involuntary commitment. Now, this is not a guardianship or conservatorship. This is where you're basically saying, Judge, my next door neighbor is doing this or that, and I need the court to take charge of them, to bring them in to a safe place. Usually, it could be Shelby Medical, it could be UAB, it could be Woodwood Hospital, and to examine them to find out what their problem is and to make a determination about what they might need. So the court would order the sheriff, usually it might be the police department if it's within the city limits, to go out and literally pick somebody up and with a police car, take them down to the hospital, put them into the psych ward, and find out first, are they addicted to drugs or alcohol? If they are, that this might not be appropriate. But if they're not, if they have bipolar disorder, the psychiatrist would say, Judge, this person suffers from untreated bipolar disorder, and they need to be medicated and find out what's going to work, and then maybe they could be released back into the independent society. So the court would then order them to go to Tuscaloosa for maybe a month to find out what exactly is going to work on them. So that's an involuntary commitment, and that has nothing to do with the guardianship or conservatorship, but I wanted to mention that as another option for people out there. So we have gotten to 10 minutes before the hour, and I guess it's a good time to ask any questions that might come up. These are our numbers in our email, by the way. Jennifer, who some of you have met, and Valerie's our new lawyer. She's also aware of or familiar with all of these as well. So our phone number, our email, and our website, where we have a lot of blog posts about these issues and other issues that might be handy for you. So feel free to reach out to us anytime you need help. We're happy to pick up the phone and answer your question if you're sitting there with a family. Any questions?
One question we had, Bill, was whether we could get the slides for this to pass out to folks at the end.
Sure, I'll email them to you, and then you can pass them along to everybody if that works for you.
That'd be great. I don't see any other questions. Our password for today is Nolan, as in Bill Nolan, our speaker, which is spelled capital Nolan. We have some thank yous coming in. Please join us on, here's a question. If an incapacitated adult needs a guardian, does the guardian have to live in proximity to the ward?
As I mentioned earlier on, generally, yes, because a guardian's job is to be involved in the day-to-day life of the person in need of protection. So if the person's still in their home or an apartment, then yes would be the answer. But if a person's in assisted living, memory care, or skilled care, you could say because they are safely living at Fairhaven, the guardian lives elsewhere, and that would be fine.
Here's another question. Does a prospective guardian or conservator have to pay all the legal fees for the process?
Upfront, yes, although those fees would be refunded to the parties upon the successful appointment of guardian conservator.
Okay. Now, if you mentioned early in the call, if someone sold a home as a conservator, what would be the penalty without having the court's knowledge of it?
I would say that the biggest penalty would be revocation of the conservatorship because they violated the terms of the conservatorship. And they might not be bondable in the future because the bonding company might hold that against them. I don't think they could be thrown in jail or anything, but it certainly would not bode well for anything they're doing in the future in these areas.
Financially.
Yeah.
And please join us, y'all. We don't have any, does POA paperwork have to be notarized in the state of Alabama?
Yes, a proper power of attorney should be notarized, although it doesn't have to be witnessed. Witnessing doesn't hurt it, but it does have to be notarized.
Okay. On Monday of next week, we have Enhancing Ethical Interprofessional Communication and Collaboration and Ethics Unit with Latasha Tony, who I believe is on our call today with us. Ms. Tony, is a somewhat frequent visitor to our CEU topics and indicated on the evaluation, which I hope all of you will do, that she would like to be a speaker in an upcoming event. And so we're going to feature her on Monday of next week in ethics unit. So if you're needing an ethics unit, please make note of that. We have another question. Do you have to be the conservator if you are chosen? Can you say no?
Yes, absolutely. I can't imagine how you could get to the point where it would come up that way, because there are several steps that have to be taken to get to the hearing. But let's say that something comes up in your life, your own family needs your involvement more than your mom. You can always say, Judge, thank you, but no thank you. And then they would probably pass it along to the county conservator to take over.
Okay. And if a patient feels like he is being taken advantage of while having a conservatorship, what are the next steps to get that investigated?
Ooh, that I've had people do that, call me from somewhere and say, my conservator's cheating me, my conservator's taking all my money. And the fact is that just doesn't happen. And the court is reluctant the court wants to make sure that you're being properly taken care of, but the court's also heard it from many people in the past that they're being cheated or stolen from, and it's just not the case. So it's sort of like the boy that cried wolf, the court's jaded in hearing those. If a person really did truly feel that, the court can certainly ask the conservator to provide an accounting to the court to see if what's truly going on. But I've done this for years and I've never seen a conservator, be able to beat the system that way. I have seen executors beat the system that way, but not conservators.
What if a patient is alert and oriented but has severe ETOH and can no longer care for themselves, multiple hospital admits?
Well, you don't have to do both the guardianship and conservatorship. Some people might be perfectly fine making their own personal decisions, but need help financially. In that case, just a conservatorship would be necessary. On the other hand, you might have a person who is of relatively nominal means. Let's say that they live in an apartment and other than their personal belongings, their only source of income is their Social Security check or teacher's retirement. Well, in that case, you don't need to have a conservator appointed. You just need a guardian to help them go to the doctor and take care of things. And the guardian can become representative payee for their Social Security. And that way you can avoid all the accounting business that a conservatorship would require.
If you decide you don't want to be a conservator or guardian as an adult child, how do you start the county process? Should you call in DHR?
No, I think you would go back to the court and say, Judge, I was appointed conservator last year and I had no clue it was going to require this much of my time or effort, and my health has declined and I can't do it anymore. I'd like to withdraw as conservator. Now, ideally, you could say, however, my brother here wants to step up to the plate and take over. But if you wanted to turn it over to the county, you could. You just have to do a final accounting that says, this is how I've managed the money up until this time, and I'm asking the court what to do with it from this point forward. It would require another hearing.
Okay. That seems to be the last of the questions. Thank you again so much for being here, Bill. We always appreciate you and look forward to having you back in the future, depending on what topics you'd like to share with us at that time.
Well, it's always fun to be here, and anytime I can help, just let me know.
All right, that's great. Thank you, everyone, for being here. Please join us Monday for an ethics unit with Latasha Toney. Thank you for being here today. I hope you go out and have a great week. And remember, our password is Nolan, as in Bill Nolan, with the Alabama Elder Law Care Farm. NOLAN, capital NOLAN is the password. Thank you for being here, and y'all have a great